what I mean? Yeah, no, I see exactly what you mean.
Good morning, everyone.
Good morning.
I don't know how smart it was to have this meeting 3 days before Christmas and Hanukkah, but be that as may, here we are. Is there a motion to accept the minutes of the last meeting? It's unanimous with the abstention of the Health Department.
And Hari.
And Hart. I'm going to ask Simone Salam to introduce a proposed rulemaking regarding repeal of Department of Buildings penalty schedule from one set of rules in anticipation of the Buildings Department adopting its penalty schedule within their rules.
I'm Simone Salam, Assistant General Counsel, and there's not much to say about it. We're proposing the repeal of the building's penalty schedule, which is found in Section 3-103 of Subchapter G of Title 48 of the Rules of the City of New York. It contains penalties for violations issued by the Department of Buildings for violations of Title 1, 27, and 28. One of RCNY 27 and 28 of the Administrative Code. DOB is proposing their own penalty schedule and their own rules, and we're coordinating to make sure that there's no lag in that, so the rules will be repealed at the same time that the new penalty schedule goes into effect. This is part of the retrospective rule review that we're working with the mayor's office on to repeal the legacy penalty schedules out of our rules and have new penalty schedules promulgated by the enforcement agencies. So if anyone has any questions.
Ernest Cavallo, citizen member. I continue to oppose this wholesale repeal of the rules that this board voted on, and having the agencies themselves promulgate their own rules without a layer of scrutiny, that having citizen members review the various proposals. It's less transparency, it's not more. It's a bad government initiative. It will remain a bad government initiative. It fixes a problem that does not exist. An extra month in putting a rule schedule into effect is not justification for this wholesale change in the way we have done business for years. That's all I have to say.
Any other questions? Is there a motion? You don't have to, but you can. There's a motion. Is there a vote? Okay. 1, 2, 3, 4, 5, 6.
Opposed.
One opposed. Any abstentions? One abstention. And 3 abstentions. Thank you. Simone?
Okay, the next proposal that we have for your consideration is the repeal of the noise code penalty schedule. This schedule is found in section 3-115 of subchapter G of chapter 3 of title 48 in the rules of the City of New York, and contains penalties for notices of violation issued by DEP for violations of title 15 of the RCNY, titles 10 and 24 of the Administrative Code. And similarly, DEP is proposing a companion rule adding the noise code penalty schedule to title 15 of the RCNY. Again, this is part of the retrospective rule review. It is also part of the Criminal Justice Reform Act, a local law was passed that changes the penalty amounts for some of the noise code violations, and so that goes into effect in March, which is why we're bringing the repeal to you now, so that DEP can get their new noise code penalty schedule in effect by that date. Any questions?
Ernest Cavallo, citizen member. I oppose it for the same reasons I opposed the previous proposal.
Any other questions? The motion? All those in favor? 1, 2, 3, 4, 5, 6, 7 in favor. All opposed? 1 opposed. Abstentions? 2 abstentions. Thank you. DEP has a request for a cease and desist order. Councilman, please.
Good morning. I'm Russell Pecunes with DEP's Bureau of Legal Affairs. This morning, DEP is asking the board to approve a cease and desist order under the sewer code. The respondent is Brunch NY Incorporated at 161 Division Avenue in Brooklyn. This is a non-residential establishment where food is prepared. An inspection determined that the respondent was not needed to install a variety of grease interceptors on various sinks and drains. Subsequent inspections determined that on existing grease interceptors, they were severely overloaded. After a series of inspections showed that respondent had still not complied with commissioner's orders to come into compliance with the code. The Bureau of Wastewater Treatment determined that a request for a cease and desist order would be appropriate, and that respondent should be required to appear and establish that they have installed and are properly maintaining appropriately sized grease interceptors at this location. So based on that, DEP is asking the board to approve an order to cease and desist.
Any questions? Motion? I think it's unanimous with 1 abstention.
Yep. DEP also has 4 requests for cease and desist orders this month under the noise code. The first is Hillview Specialty Foods at 2787 Broadway in Manhattan. This location has been cited on 5 occasions, 1 last year and 4 this year, for noise from the kitchen exhaust based on the continuing violations and continuing failure to come into compliance. DEP is asking the board to issue an order to cease and desist.
Questions? Motion? Again, it's unanimous with 1 abstention.
The next one under the noise code is 515 Madison Group, located at 515 Madison Avenue. This location has been cited on 3 occasions this year, since March, for noise from the kitchen exhaust due to the continuing violations and continuing failure to comply. DEP is asking the board to issue an order to cease and desist.
Question? Motion? And again, it's unanimous with 1 abstention.
The third one is Birds and Bubbles LLC at 100B Forsyth Street in Manhattan. This is a restaurant. There have been 5 violations cited, 3 last year, and 2 this year for noise from kitchen exhaust due to the continuing violations and failure to come into compliance. DEP is asking the board to issue an order to cease and desist.
Questions? Motion? It's unanimous with 1 abstention.
And finally, we have one that's not a kitchen exhaust. This is Bedford Auto Repair LLC, located at 1232 Bedford Avenue in Brooklyn. This location has been cited on 3 occasions since May of this year from noise for the generator. We do understand that the landlord is attempting to evict this tenant. However, since that has not happened yet, because of the repeated violations and continuing failure to comply, DEP is asking the board to issue an order to cease and desist.
Questions? Motion? Unanimous with one abstention.
And finally, we have the 28 requests for cease and desist orders relating to failure to install backflow prevention devices. In each of these cases, the building owner has been ordered to install appropriate backflow prevention devices. They have failed to comply. They've been issued a summons, which has been adjudicated in violation. They're still not in compliance. Based on that, DEP is asking the board to issue an order to cease and desist in each of these cases. And I would just note that there was actually this past week a real-life case of a backflow incident in Corpus Christi, Texas. A chemical was introduced due to a faulty backflow prevention device from a company that makes asphalt. And the tap water was off limits in Corpus Christi for 2 days because of that incident. So every once in a blue moon, there is an actual event which occurs, and it does illustrate why we do enforce this. And so, although it's rare, it does happen.
Questions? Motion? Unanimous with one abstention.
Thank you.
Pre-sealing orders.
Good morning, I'm Kelly Forshell, Assistant Director for adjudications for Oak Clearance Division. And this morning we have 22 pre-sealing reports. 18 of these involve backflow violations, 1 involves an air code violation, 1 involves a noise code violation, and 2 involve sewer code violations. 18 of the pre-sealing reports involve backflow violations, and in all of these cases, the hearing officers recommend no sealing or other action based on the respondent's evidence of compliance that was presented at the hearings. The air code case, the respondent did not appear for the pre-sealing hearing. However, DEP recommended that the C&D order be discontinued because DEP had a recent inspection of the premises showing that the site equipment had been removed. So the hearing officer in that case agrees with DEP's recommendation that the C&D order be discontinued. In the noise case, the respondent's representative came to the pre-sealing hearing and presented evidence of work done on the elevator door. This was a parking garage, which had an elevator door which was, the elevator door unit which was causing the noise. They showed that the equipment had come into compliance at the hearing, and the hearing officer is recommending that DEP re-inspect the equipment forthwith and that the equipment remain unsealed if that initial re-inspection and further re-inspections for a period of 180 days show no violation. And finally, in the 2 sewer code cases, the respondents did not appear for the pre-sealing hearings, but DEP has recommended that the C&D orders be discontinued because the respondents have come into compliance with the sewer code. And the hearing officers in both cases agree with DEP's recommendation and recommend that the C&D orders be discontinued in both cases. That's it.
Questions? Motion? Unanimous. Is there a motion to go into executive session for the judicial report? Unanimous? Okay. Thank you. I just want to bring up one thing before we adjourn. The next meeting had been scheduled for January 27th, but it turns out there is a major conflict, time conflict on that date. And we're going to see if we can poll the folks here to reschedule it either later in the day or the following Monday, the 30th. And we'll reach out to you guys and sort it out, and we'll figure it out, let everybody know. Thank you. We are adjourned. I assume everybody's in concurrence that we are adjourned? And happy holidays, and see you next year. I always love saying